All right, thank you. Court is calling 2025 CR 0022723 State versus Leroy Smith. Can I have parties announced for the record? State.
Andrew Harris, state of Texas. Actually, Ashley Jones is chief.
All right.
And Michael Leon for Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
Any objections to Mr. Smith appearing by Zoom?
Not from the state, Your Honor.
All right, we're here for a defendant's motion to reduce bond. State, have you had a chance to review the motion?
I believe we did yesterday, Your Honor, yes.
All right, and is there an agreement?
Your Honor, the state would recommend that the original bond be slated with the without things. And I believe that's the 1%.
All right, defense, I'll hear argument.
Judge, Mr. Smith appeared on Monday, April 21st, approximately 2 weeks and 1 day ago, on his first appearance. He was 20 minutes late to court. The visiting judge at that time put him in the box and revoked his bond for being late to court. The next day after that, he had to go from the jail to University Hospital for dialysis. That's what he needs as part of his medical condition. He was late to court, Judge, and he apologizes for that. You know, he was trying to find the courtroom and everything. He's got no prior criminal history. He will appear in the future. He's had that $30,000 bond for approximately a week and a half, almost 2 weeks. And with the $30,000 bond, he can't make it. We would like a bond reduction of respectfully anywhere between $5,000 to $10,000. And he and his wife can potentially make that type of bond. And of course, he'll make all his court appearances at that point.
All right, Attorney DeLeon.
Yes.
I see that you were here on May 6th in the court. The court set his bond at $30,000, the original amount which the state was agreed to. And you're saying that he no longer can make that. Has anyone called the bondsman to see if the bondsman will be on his bond with the $30,000, perhaps taking in consideration that he's already paid towards the $30,000 bond? Has he spoken to the bondsman?
Well, Judge, the original bond was revoked. Mr. Smith, do you have any information for the court about your bondsman?
So when I talked to the bondsman, he told me that I did not show up for court, so therefore that's why it was revoked, and that I would have to pay basically $1,500. And I was like, I don't have $1,500.
Hey, sir, can I get a paper?
Well, maybe, Mr. DeLeon, if you want to talk to the bondsman and explain to the bondsman the circumstances of his showing up, who knows, maybe the bondsman will reconsider and place you under the same contract with that amount having previously been paid. Once, Mr. DeLeon, you've spoken to the bondsman about that, I'll rehear the case if the bondsman says no.
Okay.
And if you want to speak to them today and recall this for tomorrow, and we can have your client appear by Zoom tomorrow, the court will take it up.
That'd be fine, Judge. I'll reach out to the bondsman right now.
All right, thank you.
Thank you, Judge Boyd.
All right, you're welcome. You're welcome. Court is calling 2024 CR 012475, 2024 CR 011906, State versus Sean Pilkington. Can I have parties announced for the record, please?
Hunter Morris for the state.
Lindsay Shaw for Ms. Pilkington. Mr. Pilkington.
Thank
Sorry.
you. And are you Mr. Pilkington? All right, so that is in cause number 2024 CR 011906. So state you are waiving the repeat offensement enhancement allegation.
That is correct. And count one.
Any objection?
No, Your Honor.
And judge, in the other cause number, state is proceeding on paragraph B of count one and waiving the habitual enhancement, but keeping the repeater enhancement for the 2019 cause number.
All right, so waive habitual, and you say you're proceeding on paragraph
B.
B.
It should make that one effectively a second degree.
And the cause number ended in 06. You're charged with fraudulent use or possession of credit card or debit card, 10 to 50 items as a second degree felony. And the cause number ending in 75. They're proceeding on the count with fraudulent use of possession of identifying information, 5 or less for the elderly, with the repeat offender enhancement allegation. Each of those offenses, the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. And each of the cause numbers, did you review the plea bargain agreement with your attorney? Did you understand it? And the cause number ending in 06, according to the plea, the state is proceeding on count 2. Punishment is to be assessed at 8 years in the prison. There's a $2,000 fine, no applications. This will run concurrent with 2024 CR 012475. State will take in consideration 2024 PF 26211, 2025 CR 001487, NIGHTMAG number 766582 with a corresponding JN number 2181185. Restitution, if any, to the complainants. And the cause number ending in 75, state is proceeding on count 1, paragraph B. You'd agree that you've been previously convicted of 1 or more felonies for enhancement. Punishments be assessed at 8 years in the prison. There are no applications. There's to be restitution of $902 to Randolph Brooks Federal Credit Union, and there's to be no contact with Shirley Rushfelt. And each of those cause numbers, did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State?
Yes, Judge.
Then in cause number 2024 CR 012475, how do you plead? Guilty, not guilty, or no contest to paragraph B?
Contest, Your Honor.
And to the enhancement, how do you plead? True or not true?
True.
And in the cause number 2024 CR 011906, how do you plead? Guilty, not guilty, or no contest? And that is to count 2, correct? All right, each of the cause numbers after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, ma'am.
Anything you want to say on behalf of your client?
Your Honor, I think it's evident just in looking at his criminal history, a lot of the reason that this keeps happening is because Mr. Sean has struggled with drugs. His father is here in support of him. He's he's here because he wants the court to know and Sean to know that he's going to support him through this. We just ask the state that the court follow the plea agreement.
In each cause number, the court will sentence you to 8 years in the prison. In the cause number ending in 75, there's a restitution to Randolph Brooks Federal Credit Union in the amount of $902. There's to be no contact with Shirley Rushfelt. And the court is, as previously stated, the court found the enhancement true. And cause number ending in 06, the court has sentenced you to 8 years in the prison. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2024 CR 012475. State will take in consideration 2024 PF 26211, 2025 CR 001487, NIGHTMAG number 766582. All right, we can go off the record. Here's the thing. A lot of people have drug problems. I understand the issues with that. I appreciate when that happens to people, but you can't use your addiction to build your happiness off somebody else's misery. All of those people, guess what? They got to change their bank accounts. They probably got to have new social security cards, all of that. So here's the thing. If you want to truly maintain your sobriety, you can do that, right? There are plenty of places that will help you, but if you don't pick up the phone, and is there something for me to sign? If you don't pick up the phone and call somebody for help, nobody knows you need help. And when nobody knows you need help, there's nothing they can do. What's going to end up happening to you if you don't maintain your sobriety? Only 2 possible things can happen. 1, you end up spending the rest of your life in prison, or 2, somebody ends up identifying your body, because you can get a hold of bad drugs and then people overdose. It happens, right? And if your body is found on the side of the road or in a field, you know who's going to have to come identify your body? Your parents. And I don't think you want that. You understand? When you're released from prison, if you can't find a place that can help you out, if I'm still here, you can come back here and I will find a place for you. Do you understand? All right. You're welcome. Good luck to you, okay?
Thank you, Judge.
You're welcome. All right, court is calling 2020 CR 7235 State versus Moses Albert Martinez. Can I have parties announced for the record?
Jason Garrett here for the state.
Defense?
Lindsay Shaw for Mr. Martinez.
And are you Mr. Martinez? Are you the same Moses Albert Martinez who was placed on deferred adjudication in 2020 CR 7235 for the offense of possession of a controlled substance penalty group 1, 4 grams to 200 grams on May 23rd, 2024 for a term of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 41, on or about the 11th day of April 2025 in Bear County, Texas, the defendant Moses Albert Martinez who did and failed to comply with the rules and regulations of the felony drug court in violation.
All right. So we can go off the record. Just one moment. All right, so the motion to revoke should read possession with intent to deliver. And he's actually on probation for 2 counts. He's on probation for counts 1 and count 2. And let me see. And count 1 was count 1 was possession with intent to deliver. And count 3, and I'm sorry, he's on for counts 1 and counts 3. And count 3 was possession with intent to deliver as well. And they're both first-degree felonies. All right. So you were placed on deferred adjudication for count 1 and count 3, and both are possession with intent to deliver a controlled substance penalty group 1 of 4 to 200 grams. Any objection to the motion to revoke reflecting that it is possession with intent to deliver?
No, Judge.
All right. So you've entered a plea of true to violation of condition number 41. Did you understand by entering a plea to violation of condition number 41? And I'm assuming this is for both for counts 1 and counts 3?
Yes.
That by entering true to 41 in count 1 and in count 3, both of those carry a range of punishment of anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? Knowing that, do you still wish to plead true to violation of condition number 41 and counts 1 and 2? I'm sorry, counts 1 and 3. The court will find violation of condition number 41 and counts 1 and 3 true. Is there a proposed agreement?
There is, Your Honor. It's deny the motion, continue him on his probation, and have him alter and amend his condition to include state ISF with that.
All right, so what I can tell you, you're gonna have 2 choices. 1, I can revoke you. I'll sentence you to 5 years in the prison. Or 2, I can continue you, but you're going to safety. So those are your only 2 choices. There's no third option.
Can I say something?
Sure.
Drug court really helped me, and I messed that up, and I learned my lesson, but it did show me how to be sober. And as you can see, everything I was doing good is just, it was an old phone, this, and I don't got nothing. It was an old phone, and it was an old number, and I got rid of it. So here,
It's not allowed.
I know.
I know what the issues were with felony drug court because they just don't release somebody because of phone. So there's more going on. And it wasn't an old phone because when you're in felony drug court and you're in actively in treatment, you know to change people, places, and things. And part of your changing things was that phone and what you were doing with that phone. All right, the court will deny the motion, alter and amend conditions to include safety. And he's to remain in custody until he's transferred to safety. And that's with aftercare. And then after he's completed those 2 things, let's do another referral to felony drug court after completion and see if they change their mind. If they don't change their mind, then have him brought back to court before he's released. All right. Is there anything else you need from the court? You're welcome. All right, we can go off the record here on out. You're looking at life in prison. Is it worth it? All right, you better start acting like it, okay? You. All right, court is calling 2024 CR 1810 and 2024 CR 1811 State versus Jason Densler. Could I have parties announced?
Jim Altersdorf or Jason Densler.
And are you Jason Densler?
Yes, Your Honor, I am.
And each cause number, you're charged with credit card or debit abuse with a repeat enhancement allegation. If the state is able to prove up the repeat enhancement allegation, then your range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Did you review the plea bargain page with your attorney in each of these cause numbers, and did you understand it?
Yes, Your Honor, I did.
And each cause number, according to the plea bargain agreement, the cases are to run concurrently. There to be no contacts with the complainant and restitution to the complainant. Punishment is to be assessed at 4 years in the prison, and there are no applications. Did you understand that to be the plea in each of these cause numbers?
Yes, Your Honor, I did.
Defense, is that the plea?
It is, Your Honor.
Then in cause number 2024 CR 1810, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2024 CR 1811, how do you plead? Guilty, not guilty, or no contest?
No contest.
After reviewing states exhibits 1 and attachment in each cause number, the court is going to find there's sufficient evidence to find you guilty. In each cause number, the court is going to find the enhancements true based upon your plea are true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I took him from the court, the competency court to this court, and he's a nonviolent offender. His history is of a nonviolent nature, including his enhancements. I'd ask the court to file the plea bargain.
All right, let's discuss the restitution. And cause number 2024 CR 1810. What is the restitution amount? I saw something in the steps that says $6,300. I don't know if that's total or not.
That's one case, Judge.
I thought that was in the.
I've got it backwards, Judge. 2024-1811, I believe is 63, around 6,300. That would be to George Salinas.
All right, no, actually, George Salinas's, it's
sorry.
not the 6,300, the other complainant in the 810.
Sorry.
Right, on the cost number ending in 11, the amount is 6,300. And that's to John Kelly Valadez. And in the cause number ending in 10,
Wait. So 11,
yes.
you're saying that's the 6,300 to Valadez?
Yes.
Okay. And the 10,
0 it's 1,300 to George Salinas Jr.
all right, so in that case, I saw that they said there were 2 MacBooks and they were valued at $13.99 each, and there were 2. Am I reading that incorrectly?
No, you're reading that correctly. That's to the design company, which is Mr. Valdez, I believe. Is that right, sir?
That's my recollection.
Yes, sir.
So, I mean, is it $13.99 times 2?
Yes.
And so where's the $1,300 coming in?
I believe that is how much was used on the card.
That was the ATM amount, I believe, on Mr. Salinas.
Well, then I put it at $4,098.
Yes, ma'am. Yes, ma'am. That's fine.
All right, so let me do this. And cause number 2024 CR 1810. The court has previously stated is finding you guilty. The enhancement's true. This is the run concurrent with 2024 1811. There's to be no contact with George Salinas Jr. There's to be restitution of $4,098 to George Salinas Jr. And there's to be 4 years in the prison, credit for any time served. Is there anything else with regards to that cause number?
No, Your Honor.
And then in cause number 2024 CR 1811, the court is finding you guilty. The court is finding the enhancement true. This will run concurrent with 2024 CR 1810. There's to be no contact and restitution to John Kelly Valadez in the amount of $6,300, 4 years prison, credit for any time served. Is there anything else with regards to sentencing in that cause number?
No, Your Honor.
All right, we can go off the record. Here's the thing. You're gonna have to make decisions in your life. Do you want to continue to steal? You know, everything that you stole, is it worth 4 years of your life?
No, ma'am.
You cannot be building your happiness off somebody else's misery. I know your counsel said these were not violent offenses, but people were still violated. Now you have somebody who perhaps because you took $6,300 out of their bank account, maybe they have payments that come out of their account, their mortgage, their utilities, and maybe all of that bounced because you stole from them. Can't do it. If you have a drug or alcohol problem and need help with that, there are plenty of places in San Antonio that are free. I'm not the judge in this court, it's Judge Murray, but when you're released from prison, if you can't find a place to get help, if you have mental health issues, if you have drug issues, if you have housing issues, if you can't find a place that can help you, you can always come back to court. If I'm here, I will pick up the phone and call to get you help. You understand?
That's great. Thank you.
All right, you're welcome. Good luck to you. You're welcome. Right, court is calling 2024 CR 2071 and 2024 CR 007676 State versus Hank Maldonado. Can I have parties announced?
Andrew Harrison, State.
David McLean for the defense.
And are you Mr. Maldonado?
Yes, yes, Judge.
In each of these cause number, you entered a plea of no contest. According to your plea bargain agreement, and each cause number, punishment is to be assessed at a cap of 12 months in the state jail facility. The state is opposed to your application. The cases will run concurrently. The state is taking in consideration 2024 CR 1039. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state? Defense?
No, Your Honor.
All right, state you're opposed. Why?
Reading the PSI, it seems that Mr. Maldonado is still in denial about certain things. The first is his history of drug use and whether that constitutes, while I am not qualified to say whether someone is addicted to substances or not, it does seem to me that 3 arrests over a period of 10 years for illicit substances, one case leading to a person being sentenced to confinement, seems to be serious negative outcomes that the persistent engagement in those behaviors would seem to indicate an addiction. Mr. Maldonado does not seem to have a good track record of appearing when he is required to do so. His previous controlled substance case, he was ultimately revoked and sentenced to 2 years for the resisting and evading cases for which he is still pending. He failed to appear on December 1st of 2023. So going back to 2011 or going back to 2023, Mr. Maldonado seems to have an unfortunate tendency to not take his commitments to the court seriously. And based off of that history, it doesn't seem like he's going to be any more committed to meeting these requirements today.
All right, defense.
Your Honor, on behalf of my client, I reviewed the PSI and the TAP. The TAP evaluation seems to indicate that he does not have any kind of serious drug or alcohol problems. They were recommending basically urinalysis, not even an outpatient program. I think he's addressed those issues. In all candor to the court, we had a PSI set for Mr. Maldonado, and he did not appear, and he did take off for quite some time. I've talked to Mr. Maldonado about it, and he is basically just terrified of going to prison. That's really what it boiled down to. And with kind of this opposed type of offer, he was very nervous about coming in. And some people have a fight or flight, and he took off. And I tried, Your Honor, to get him back in, and it was just something that he was just too afraid to face. And that's just being honest with you. I think he could be successful on probation. I do. He's got a business. He works with his wife. I think it's something that he could be productive. He hasn't gotten in trouble while he's been out, which is not an excuse, but it is at least something where he's not just going out and reoffending again. We would ask the court to at least consider the application for deferred and place him on probation.
All right, Mr. Maldonado, you were scheduled to appear for court. You did not appear. That's a sign that you won't be a good candidate for probation. I'm looking at your criminal history, and you have a burglary of a vehicle from 2011. You were sentenced to 80 days in jail. Then you had a possession of marijuana, which I understand people see that differently now. That was dismissed because you were convicted of something else, which tells the court that it was taken in consideration. Then in 2011, you had a possession penalty group 3, 28 to 200 grams. You were placed on deferred adjudication for 4 years out of the 186th District Court. Probation was revoked and you were sentenced. They amended it and just sentenced you to 2 years in the prison. And then in 2023, you had another case, book dismissed. And then you had these 2 cases that you were set to appear before the court and you failed to appear. How old are you?
33.
So you're 33. You're not a teenager. So why you would steal someone else's vehicle or use it without permission is beyond the court's understanding at a person your age. In each cause number, the court is going to find you guilty, sentence you to 12 months in the state jail facility. The cause numbers were run concurrently. Take in consideration 2024 CR 1039.
I apologize for interrupting. Is
Yes.
there already a dismissal form on file for that cause?
I'll have to have the clerks look and see.
What was that case number again, Judge? I'm sorry.
It's 2024 CR 1039. In each cause number, there's to be restitution and no contact with Richard Anthony Johnston and also Felix Francisco Citero Rivas. And I recommend the therapeutic community. He says he doesn't have a drug or alcohol problem, but there has to be something wrong with you, or either you're just someone who likes to steal and take what doesn't belong to you. And it probably would have been in your best interest. Well, not probably. I know it would have been in your best interest to have appeared on your sentencing date. Who knows what would have happened if you would have. All right. Good luck to you.
Thank you, Judge.
You're welcome.
Thank you.